let me go to Smita Prakash.
Okay.
I think on a
But
day
you
when
need
the
to let
Supreme
me answer
Court,
that.
when the
Okay.
Supreme Court has upheld the validity of some of the provisions of PMLA, it is also worth pondering on the record of the Enforcement Directorate itself. Just yesterday in Parliament, the MOS Finance Pankaj Chaudhary gave out these figures that in the last 8 years, the number of raids undertaken by the Enforcement Directorate is 3,000. The value of property which has been attached as proceeds of crime, quote unquote, is 99,000 crores. In the 8 years between 2005, 6 and 2013, there were only 112 raids, and the value of property attached was 5,000 crores. This is the point that the opposition is making, that it has gone manifold simply to use the agency as an instrument of harassing the opposition.
True. See, who brought about the changes in the PMLA giving more powers to the ED? Sitting outside the realm, I'm not even going to mention which party because I think everybody is smart enough to know which party. Now, sitting outside the realm of these political parties, it's amusing to see the two largest parties calling ED a tool. Each of them is, accusing the other, and we sitting outside know what happened. As far as what you were saying about the BJP, actually wearing this as a feather in its cap, the Treasury benches in Parliament are not going to get cowed down by the opposition charges that ED is being used as a tool by the BJP. In fact, they're wearing it as as a badge of honor, because they are saying that the raids and the confiscation of properties that are being conducted, they say that during the UPA tenure there was no confiscation of properties of the convicted people, even though PMLA existed even then, which means that they were laggards in enforcing a rule which they themselves brought about. So the BJP says it's part of their manifesto when they talked about black money, etc. So they are going about doing that. As far as the Supreme Court is concerned, it seems a little harsh to many people who are seeing this and saying that why did they uphold everything? Many of them thought that there'd be some kind of a watering down. If I may, be bold enough to second judge or to wonder what was behind this, but I would just say that when the Supreme Court equates money laundering with heinous crimes like terrorism, then it's quite natural that they will go beyond saying that it is going to damage just the social and economic fabric. It's going to uphold the stringent provisions in the PMLA because they feel that it's about high time, because the international gaze is on India, because the entire term hawala, the whole thing is if somebody goes about money laundering, what is the synonym for hawala? Synonym for money laundering is hawala. Where does the word hawala come from? It comes from India. So this dirty tag that India has about money laundering, that's the reason the Supreme Court is saying that we are not going to water it down, because the entire world's gaze is on us.
Okay. Now, I want to ask Shantanu Guha. I think the point that the opposition is making also is not just about, the record of the ED. We will get into the details of the stats of the ED's record over the last 17, 18 years of the PMLA. But more than that, what they're saying is, what about the cases that were there against, people who are there in other parties who then joined the BJP? Hemanta Biswa Sarma joins the BJP, cases against him go into the cold storage. Mukul Roy, Shubhendu Adhikari. It's almost like, the BJP is like a Behti Ganga, and you wash away all your crimes in that Behti Ganga. Is that a valid opposition argument or opposition
No,
attack?
not at all. No cases are closed. The cases may slow down. Now, what is this PMLA? It looked like an independent act. I mean, was this envisaged by Parliament? I really don't think so. I'm not very sure about it. But cases always happen, and cases remain in files, and they keep happening. Now, let's not forget that today Karthi Chidambaram is raving and ranting, and it was his father who kept on increasing the ambit of PMLA. Yeah. In 2002, there were only 5 offenses under PMLA till PC kept on increasing it. Now, probably he should have also realized that there is no government is there for life. And he should have realized that any unbridled power given to an executive eventually turns out to be perverse. What are we seeing here? What we are seeing here is basically the government is trying its level best to unearth illegal cash. It is not an easy task. Don't forget, in this country, the Hassan Ali case is still unresolved. Mm-hmm. So tracking hawala cash, tracking cash under PMLA is not easy. So, certain stringent measures have come in. Now, there has been two amendments, 2013, 2019.
Yeah.
Now, P and C, which is basically the C being the scheduled offense and P being the financial benefit out of it, are an integral part of this act. What is being done now is that you enter, seize, arrest, and then find out about P and C, and that the opposition is not liking. They are saying, tell me why I'm being arrested. I don't think the ED explains that. ED need not do that. If they start explaining it, time and again we have seen opposition people coming out on the streets and objecting to investigations.
No.
That's not a good
My simple contention question is really, and I want to ask the lawyer on the panel, Mr. Tanai, if for various provisions of arrest under IPC or CRPC, an accused has rights of the accused under Article 22(1) of the Constitution, where he or she should be told at the time of arrest what grounds he or she is being arrested under. Today, the court, in the case of the PMLA, has said that it is not mandatory for ED officers to disclose the grounds of arrest at the time of detaining an accused. And more importantly, it has also gone on to say, it went on to say that it is not necessary to give the ECIR, which is the Enforcement Case Information Report, or the equivalent of an FIR, or a copy of the complaint to the accused, because it is an internal document of the ED.
Correct.
Why should this provision of law have a different standard as opposed to all the other laws in the CRPC and IPC?
Oh, well, the very first thing is the crimes are committed in utmost secrecy. And in this case, if we see, no criminal comes out here by its own self. It is the ED by its own mechanism that they find it out in the system that what is wrong or what is the offense which has been committed. So all the criminals who have committed or who have done the hera-pheri or who have done so, whatsoever the wrongs they have done it, ED has been investigating, and there is a complete chain which has to be find it out. The investigation gets effected subsequently. That is one of the basic reasons. During the investigation, it is not told. It is at that point of time when they are arrested, they are told the grounds, look, this is what we have find it out. And now you also can tell or you can explain these kind of entries or these kind of things which are there before the arrest. The power of arrest must be distinguished from the actual arrest. The power of arrest comes only when you find out some tangible evidence against the criminals. It is even in the ED, if they have some kind of investigation, they have a material, they investigate. After the investigation, when they find it out, yes,
no. I'm sorry, I'm interrupting. Let me give you the latest example. The example of Mr. Partho Chatterjee, who used to be a minister in the TMC government, and one of his close associates. Both of them were arrested a few days ago. Now, of course, ED is well within its right to arrest Mr. Partho Chatterjee because they have interrogated him, they have found him non-cooperative, and they have arrested him. But subsequent to his arrest, the material that's coming out into the public domain, which is the seizure of the 20 crores of cash in this Arpita Mukherjee's house, or today, even as we speak right now, counting machines have been brought in from SBI to a house that